complaints in this case. Ms. Sarah, what is it that you would like to say on your behalf here today?
Well, I still have not received any pension. It's now 5 months owed. I did receive an email from the pension company saying he finally completed the paperwork in June, which it was supposed to start in March. So I don't know where that's going. As far as his firearms, I have never had them in my possession. My son has them, and my son told me that he had talked with his father, and his father agreed that my son would hold on to them until they figured out what to do. I've never had them in my possession. So I know he keeps saying I do, but I don't know anything about guns. Why would I want them? A few were sold by my son just after I was forced out of my home. They made the car payment for a few months because I had no income, and they paid for my son's storage in California while he moved here. Also, he claims that I am late on the car payment. Well, he was supposed to pay the March and April car payment and insurance, and he never did. He still has not. I got a letter saying that, or an email saying that the car insurance is still in effect. Well, of course it is. I had to pay it, but he was supposed to pay March and April. I went without car insurance for 5 days, didn't drive the car because I had no money to pay it until I got support from him. At this time, it's over $5,000 when you count the pension, the car payments, the insurance. I don't know what to do from here. I'm at a loss.
Okay, thank you. Mr. Cutler?
Thank you, Your Honor. Couple things. First of all, I want to correct the plaintiff in this. The judgment was entered May 13th. The judgment was required in order to process the quadro. That had to be submitted because it's an order of the court. That was done, so it hasn't been 5 months. It's now in the third month, I guess, because it was on the 13th, short of the third month. My client has jumped through all the hoops. He submitted the final documentation. He'd be happy to acknowledge that under oath. So that is done by third parties, not by my client. He submitted everything he needed to submit. As far as the current status of the situation, our greatest concern, as highlighted in our motion and our answer, is that there's a car. The car is being driven. It was awarded to the plaintiff. It is being driven by her. If she runs over, God forbid, some person gets into a car accident, gets a ticket, it falls on my client. He is liable for it. No matter what she says, he's going to be held liable because he's still down as the owner of the vehicle. We believe it's appropriate that until such time, if she is ever to get a car loan and ever to take the title out of.
What happens when a divorce judgment is ignored? Sarah claims she is owed pension payments, car expenses, and thousands of dollars. Her ex-husband disputes her claims, while the fight expands to firearms, insurance, student loans, and the vehicle.
His name, that the car be parked and that it remain there. So we're suggesting the car be transported to my client's property, what he was awarded during the divorce. It will remain there, will not be driven. And nothing will happen with that vehicle, thereby alleviating the possibility of other lawsuits and other traumatic situations. We believe that's appropriate in the interim until something may or may not happen. In her answer, she indicates she went to Secretary of State and there's a lien. Well, of course there's a lien because there's a car loan on it and she can't transfer it. I don't know if she's ever going to be approved for it. So that's the initial, I think, most urgent request at this point. As far as the remaining funds, she has not paid half the money for the student loans like she was ordered. We believe that it's appropriate in order to prevent default and other further problems for the two of them, that the amount of, I believe it's $714, I put it in my motion, be credited to my client, that he can reduce that from his support obligations that he has been making, and he has done so every month. He made every payment. He's going to be fulfilling his July payment, but that amount be reduced by that $700 figure. He will pay it on their behalf, avoiding a default, and thereby alleviating further problems for the two of them until such time when maybe situation will change. As far as the rifles go, the firearms, the order of this court was very clear. If they are not returned to my client, he is to get credit for them. We added up exactly the amount for the attachment that was provided at the time of trial and as part of the decision of this court. The amount is $6,131.35. We've attached in response to her motion text messages where the plaintiff is gloating. She forged my client's signature on these firearms, on the registration, that these firearms were all sold. Doesn't matter what the purpose is. That's all water under the bridge during the trial. Since they cannot be returned and she cannot apparently pay the amount of money, we believe it's appropriate he should have credit of that amount for the spousal support. So he's not creating more problems for himself. They're never going to be returned to him. He never had an agreement with anyone in the world. The decision of this court is very clear. She's supposed to return them. She's supposed to pay for them. She can't return them. Since she doesn't have the money to pay for them, we believe a credit is appropriate for that item. As far as the remaining aspects,
his attorney argues the pension paperwork has been completed and asks the judge to stop Sarah from driving the vehicle. He also demands credit for the firearms, claiming they were supposed to be returned or financially compensated.
When we filed our motion, or after we filed the motion, it appears that the plaintiff did make a couple payments on the obligation for the Highlander, avoiding a default. So I'm glad she did that for the prior months, but she has not completed the other tests. My client, on the other hand, has continued the the car insurance. It's paid through October 11th of this year because it was previously paid under a policy. It's a 6-month policy or a year policy as they typically are. So there isn't any continuing payment that needs to be made as far as the car insurance goes. But that's only short term, and that's going to be concluding pretty soon. So of those issues, we believe it's appropriate in the interim at this point in time, because we're not getting cooperation from the plaintiff, that he receive those credits, the credit for the firearm, the credit for the payment that he's going to need to make for student loans, and that the vehicle be parked and remain parked and not to be touched by either party until further order of the court, which may or may not ever happen. I'm not sure if the court had any questions of myself.
I don't. Okay. So again, I've reviewed what each party's allegations are. First, I guess I want to say, and Mr. Cutler probably already knows this as an attorney, but for Mr. and Ms. Sarah, everybody needs to understand the way that I'm viewing this. The court has an interest in and an obligation to enforce its orders. And so the court's determination is limited to whether or not either or both parties are complying with the court's orders. And if they're not complying with the court's orders, whether they have a legally recognizable excuse for not doing so. And if they don't, then what punishment or what can the court do to compel compliance? What it's not the court's responsibility or duty to do is to figure out for the parties how they're going to comply with the orders of the court. Mr. and Ms. Sarah came to this court. They asked for a forum to resolve their divorce. The court did that according to the law and rendered a decision that in the court's view was as equitable as it could be under all the circumstances. As far as I know, neither party has appealed that decision. So now both parties are stuck with what the court has ordered, and both parties are required to comply with those orders on their own. And again, it's not the court's role or duty or obligation to figure out for the parties or answer their questions or come up with strategies or solutions for them as to how they're going to comply. That is outside the scope of the court's responsibility in this case. And we're not dealing with any legal issues here. We're simply dealing with compliance.
The judge makes one thing clear. Both parties are responsible for following the divorce judgment without excuses. The court cannot manage their obligations every month, and neither side appears to have fully complied
with orders of the court, through the court's opinion, and through the judgment of divorce that was entered. As we sit here today, just based on the statements of the parties, I don't think either party has complied with the judgment of divorce. The court's opinion clearly states that Mr. Serra is required to give or provide half of his pension to Ms. Serra, regardless of whether a quadro has been entered or not, beginning on March 1st. And Mr. Cutler has not, as far as I can tell, has not alleged that Mr. Serra has done that. The point that was made here is that he's going through the process of getting a quadro, but he's receiving that money every month. There's no reason why he can't remit to her half of that money. And in any case, regardless, it was the order of the court that he do that beginning on March 1st, and he hasn't done that, regardless of whether a quadro has been entered.
And I apologize, Your Honor. I don't want to interrupt the court, but he is not receiving his full pension. He's only receiving half. Apparently, Ms. Serra needs to process some papers. So since the order of the court, he has only received half the pension. He'd be happy to acknowledge that on the record. The other half is waiting for Ms. Serra to fill out whatever form she has to fill out. I'm sorry I overlooked that portion. I'm sorry there's some confusion. I apologize for the interruption, but I want to make it clear. He has only received, since the entry of the opinion of this court, half of his pension.
Okay, well, I don't know whether that's accurate or not. I mean, Mr. Cutler, I accept your representation as what your understanding of it is. I don't know. I don't have any records in front of me that show that. All I know is what the court ordered. And I don't believe that those funds have been received. Mr. Serra was required to pay the car payment until the judgment of divorce was entered, which was in May. Apparently, he did not make those two car payments. Ms. Serra, pardon me, I'm sorry, I have a cold. Ms. Serra was required under the judgment to either return the weapons to Mr. Serra or provide him the value that was obtained for those weapons. I found, as a matter of fact, that regardless of whether it was the son that did it or Ms. Serra or a combination of both of them, somebody disposed of Mr. Serra's weapons, and he's entitled to those weapons. And so, Ms. Serra, you've got an obligation either through yourself or through your son to return those funds to Mr. Serra or return the weapons to Mr. Serra. In terms of the student loan debt, again, the parties are required to each pay half of that. It's not my job to decide how each of you are going to meet your obligation. I've simply determined that as a matter of equity, each of you should be required to pay that. And what I'm not going to do, because I can foresee this as being an issue, and I appreciate your suggestions, Mr. Cutler, in terms of crediting Mr. Serra for amounts that Ms. Serra may or may not owe to him. The problem with that is, how does that get overseen? And how does anybody really know how much Mr. Serra is withholding and whether he's actually putting those amounts towards the student loans or not? And I'm not going to hold a hearing every month and hold the hands of both these individuals every month. And
instead of immediately issuing sanctions, the judge sends both parties to mediation to find a practical solution. They must cooperate, communicate, and determine how they will meet their financial responsibilities going forward.
And make determinations on a monthly basis about who's paying what and how it's being paid. So I'm going to make this really, really simple as we go forward here. And although, again, I don't think it's the court's obligation to come up with a solution, I'm going to provide the parties with an avenue for a solution before the court issues any kind of sanctions or coercive contempt actions. I'm going to give the parties 60 days to go to mediation. I'm going to refer this to the mediator, the community mediation. in my referral to community mediation, I'm gonna outline the issues and ask the mediator to specifically address with the parties solutions so that the two of you can proceed on a monthly basis and carry out both of your obligations. And what it's really gonna come down to, because ultimately the two of you, Mr. and Ms. Sarah, the two of you are gonna have some communications. The two of you are going to have to discuss how this can go forward, because ultimately any long-lasting solution to this problem is going to have to come from the two of you and not from the court. And that's why I think mediation is appropriate as a way to potentially go forward. I'm going to ask the mediator to provide the court with a written report following that mediation as to whether or not it was successful and to what degree. Typically, I just get a short report from the mediation service indicating whether an agreement was reached or not, but in this case, I'm going to ask for a little more detail from the mediator. And then to the extent that there isn't an agreement after that 30-day period, the court is going to set this for a show cause hearing. It'll be in person here in court. If either party has failed to comply with their own obligation under the judgment or the court's opinion, or has failed to reach an agreement as to how to meet that obligation through the mediation process, then at that point, the court will determine whether there is a violation of the court's order, whether there is a legally recognizable excuse for that violation, and if there's not, then the court will issue coercive sanctions. The last thing that I ever want to do in a civil case is impose some type of jail sanction to coerce a party to comply with the court's judgment. However, I think at that point, we will have exhausted all available remedies, and both parties should be prepared to the extent that they have not complied with the court's judgment, provided a legally recognizable excuse for not having complied, then the court will issue contempt sanctions, coercive contempt sanctions, which could include fines, other coercive orders of the court, or including up to incarceration until the non-complying party comes into compliance. I want to make sure that everybody is clear that again, this is not going to turn into a monthly finger-pointing session about who's not doing what they should be doing. Both of you are adults, both capable of handling your own affairs. You both need to come up with solutions for how each of you are going to comply with your own obligations. I'm going to provide, again, an avenue through the mediation service to facilitate some communication between the two of you as to how to make that happen. And if it doesn't, then I'm left with no other option than to coerce you through the powers that I have. And I just want everybody to be clear that I will not hesitate to use those if that's the court's last option. So I will issue that order today, referring the matter to community mediation. When they reach out to counsel and the parties, everyone needs to cooperate with that process. Once I've received a report from the mediation service, then the court will set this for another hearing as necessary, and those orders will go out today. That's all I have. I need to move on to my 2 o'clock hearing. All parties are free to disconnect at this time.
May I, Your Honor, may I say one more thing?
Nope, I need to move on to my 2 o'clock hearing. I'm sorry. Thank you.
Have a good day, Your Honor.
But the judge delivers a serious warning. Continued violations could bring fines, additional orders, or even incarceration. The message is clear: follow the judgment, because the court will not hesitate to enforce it.